ladies, my lord, before I get into the meat of my submission, just a follow-up point on YM. Of course, on the Secretary of State's case, the immigration rules aren't an issue because the tribunal was required to apply the 2014 Act. So on that issue, could I now ask the court to turn up pay...
Before we get to that,
Yes.
Can I just ask, sorry, I should be in trouble. If the appellant is right and the FDT decision on revocation is restored, it appears to have been common ground before the UT that entry clearance would follow because all requirements of the Appendix FM have been satisfied. Is that still the position?
Yes.
Yes. So we only really need to decide the revocation question.
Precisely so, my lord.
Yes. Thank you.
We have checked the rules in response to my lady's question, and the Part 9 rules, discretionary grounds for refusal, don't apply in an Appendix FM case. What the suitability rules do is say that if there's a deportation order against you, you don't meet the suitability requirement. So we come back to my lord's question, and that's why that's the issue in this case.
Thank you. That's very helpful.
So turning then to the legislation, I just want to start with Section 82 of the 2002 Act, which is the appeal right. So that's for anybody with tab 2, otherwise it's page 11 of the authorities bundle.
I'm sorry, I missed that. Which page?
Page 11.
Thank you.
And I'm mindful that the court's very familiar with this provision, but it's worth looking at it because we submit that Section 117A needs to be read consistently with Section 82 and Section 84. So Section 82(1) sub B, a person may appeal to the tribunal where the Secretary of State has decided to refuse a human rights claim by P. So the reason that there's a right of appeal in this case is because the Secretary of State has decided to refuse P, in this case the appellant's human rights claim. Section 84 on page 13 sets the ground of appeal. Section 84(2), this is the ground of appeal. An appeal under Section 82(1)(b), refusal of human rights claim, must be brought on the ground that the decision is unlawful under Section 6 of the Human Rights Act 1998. Now, the court may recall, and we'll go back to Section 117A in a moment, that Section 117A reflects the language of Section 82 and Section 84. So where somebody's right of appeal is a human rights appeal under Section 82 with the ground of appeal in Section 84, we submit that they fall squarely within Section 117A, which I'll come on to in a moment. Before I do that, could I just invite the court to turn up HA Iraq at tab 23, page 300, and it begins, at page 347 at the bundle. I wanted to ask the court to read paragraphs 18(1) to 18(4) on page 355.
Paragraph 15.
It's paragraph 18,
Oh, sorry, paragraph 18.
subparagraphs 1 to 4. So we submit that this is the context in which Part 5A falls to be interpreted. And for that purpose, could I draw out three things from this particular passage? The first is at F, that the purpose of the changes was to promote consistency, predictability, and transparency in decision making, and to reflect the government's and Parliament's view of how, as a matter of public policy, the ban should be struck. Second, at 4, which is between G and H, the purpose was to produce a straightforward set of rules. That's the second thing I want to rely on. And then the third is this, that the purpose was to narrow, rather than widen, the residual area of discretionary judgment for the court to take account of public interest or other factors not directly reflected in the wording of the statute. And we submit that the appellant's construction offends against all of those things that I've just highlighted. With that, could I ask the court to turn back to tab 2, page 15 of the authorities bundle, which is section 117A. Excuse me. Now, we say on its own, section 117A1 provides and makes clear that the rest of Part 5A applies in a case like the present one. So section 117A1 says this part applies where a court or tribunal is required to determine whether a decision made under the Immigration Act A, breaches a person's right to respect for private and family life under Article 8, and B, as a result, would be unlawful under Section 6 of the Human Rights Act. And I've shown the court sections 82 and 84. That is precisely the issue which the first tier tribunal was determined. And if one goes no further in this legislation, we submit, Parliament, in its language in section 117A, has been crystal clear that this part applies. And were this part not to apply in a particular set of circumstances, one would expect to see clear language qualifying section 117A1. And then, to strengthen the interpretation, section 117A2, in considering the public interest question, the court or tribunal must in particular have regard, in all cases, to the considerations listed in section 117B, so in all cases, and then in cases concerning the deportation of foreign criminals, to the considerations listed in section 117C. So what sections 117A2 and then 3 tell you is what is required. So 117A1 says, here you go, this part is going to apply, and then section 117A2 and 3 tell the court or tribunal what it needs to do when the part applies. And that is, when determining whether interference with the right to respect for private and family life is justified, it must have regard in particular to the considerations in both section 117B and section 117C. So far,
Does that not beg the question as to what's meant by cases concerning the deportation of foreign criminals?
yes, and we say that both the word concerning and the word deportation are broad. So far as the word deportation is concerned, we do rely on IT Jamaica, I think it is. I'll come back to that in paragraph 52 of Lady Justice Arden's, as she then was, reasoning in that case. In other words, deportation means not just the act of removing someone, but maintaining their banishment. Read that with the words concerning, even without that broader meaning of deportation. This, in my submission, is plainly a case concerning deportation.
So it's the concept of deportation, not a particular phase in the process.
Precisely. And again, given the broad terms of section 117A, given the fact that the changes were made to the 2002 Act to limit the appeal rights and to say this is now the ground for everybody. You get a right of appeal on human rights ground. Parliament was obviously well aware of that when passing section 117A. 117A is broad, and the language in section 117A2B is broad. And indeed, we know from IT Jamaica what deportation means. But if one reads all of that together, it's quite clear in my submission that absent some sort of language saying 117C doesn't apply in a particular category of cases, that it does apply.
So the amendments to sections 82 and 84 and the introduction of Part 5A were all made by the 2014.
Yes, that's right. Yes, they were all made by the 2014 Act coming into force. This 117A came into force in July 2014, and looking back at section 82, that came into force in October 2014, but it was all the same act. So Parliament at the same time as introducing and radically revising the available grounds of appeal also says, and whenever a tribunal is considering this new human rights grounds of appeal, this is what the tribunal must do, and that's explained by the passage in, I think it was HA Iraq that I showed the court, which is the context for the interpretation. So again, we say one doesn't need to go any further to see that section 117C plainly applies, and that is why in our submission the contrary hasn't been argued, and indeed why courts have accepted that it applies. But I'll come on to the case law in a moment.
You don't really even need the IT Jamaica interpretation of deportation. It strengthens the case.
Yes.
But you would say, in cases concerning the deportation, if you ask yourself, where somebody has been deported as a foreign criminal and wants to come back, is this a case concerning their deportation? The answer, in a matter of plain English, is yes, it is.
Precisely so, my lady.
Concerning is quite wide, and it has to do with, concerning means having to do with it, and it does have to do with the deportation.
Precisely so, my lady.
You don't ignore it.
Precisely so, and particularly when one reads that against section 82 and section 84, which make clear what the right of appeal is, and when one is therefore dealing with a letter addressing refusal of a human rights claim concerning deportation, which this decision plainly was. So the main point that's taken against the Secretary of State is, my learned friend has accepted today that section 117B applies. I said earlier that the first tier tribunal didn't apply section 117B, and it ought to have done, and the omission from that in its judgment indicates that it did not in our submission. I can confirm, having checked the unflagged version of the Secretary of State's application for permission to appeal, that paragraph 11 was a reference to Article 8. We can make sure the court has a clean version of that. So it's accepted now that section 117B applies, but it clearly, in our submission, even if we were wrong on section 117C, has a material bearing on this case, and for that reason alone, the Upper Tribunal's decision to set aside the first tier tribunal's decision, even before we get into section 117C, was right.
Did the Upper Tribunal reason it in that way?
This is, and it's an interesting point, and given that what happens when the Upper Tribunal sets aside a decision of the first tier is that it identifies a material error of law. Yeah. It doesn't, in my experience, identify every conceivable error of law and every basis on which the decision was flawed. It identifies the material one, and on that basis, certainly in my experience, respondents tend not to file respondents' notices saying, and when making the error of law decision, the Upper Tribunal could have picked up on all of these other areas, because all that needs to happen for it to be set aside is for there to be one material error of law, and it then all comes into the mix on remaking. So what the Upper Tribunal will do is either the parties will agree there's a material error of law, and there may not then be a hearing about it, but there only needs to be one material error of law, or the Upper Tribunal identifies a material error of law. There might be all sorts of other arguments being made, but the Upper Tribunal won't necessarily deal with those, and indeed it would use up a lot of tribunal time if it did. It just identifies one, and then everybody focuses on remaking. So certainly in
Well, I understand that.
yes.
But when you come to this court, if you want to uphold the decision of the court or tribunal below on different grounds, you normally have to say so.
Well, we seek to uphold the Upper Tribunal's decision on the basis that it was right in its error of law decision, and indeed when it went on to make its remaking decision, that Part 5A applied. That's our simple case. I would add, and
Well,
it's
I mean, I understand that, but it does seem to me that saying that the first tier did not apply 117B is a different point from the point on which the Upper Tribunal set aside.
well, perhaps we read. I hear what your lordship says. We read the Upper Tribunal's error of law decision in paragraph 14, I think it is, as saying it didn't apply Part 5A at all, including 117C, and therefore there wouldn't be a need to file a respondent's notice because we're not saying anything additional or different. We're saying what the Upper Tribunal itself said in paragraph 14. But in any event, we say nothing in reality turns on that because it's quite clear in our submission that section 117C applies. So I'll come on to that now. But in practice, that is the way that the Upper Tribunal does things. But in this particular case, it has said Part 5A as a whole in paragraph 14 of its error of law decision. Anyway, I've made that point. I won't repeat it. The essential point taken against the Secretary of State in relation to section 117C relies on a provision in the rules that I'll come on to in a moment, which effectively gives the Secretary of State a discretion to revoke a deportation order on any grounds once a 10-year period has expired on a case-by-case basis. Now, as a matter of statutory construction, and before I come on to address the court about the rules, as a matter of statutory construction, we submit that even secondary legislation, still less the Secretary of State's policy, can affect the meaning of primary legislation. If section 117C is to be interpreted as not applying in a case where the person has been deported, or as applying in a case where the person has been deported but only where 10 years haven't expired, then the primary legislation needs to say so. So that's a basic point. My learned friend's argument in my submission can only be it can't go to the interpretation of section 117C. It has to be as to its application on the facts of a particular case. So if the immigration rules are to have any relevance in principle, and I'll come on to that in a moment, it can't change the meaning, the plain meaning of section 117C.
But his point of 117C is that the exceptions can only apply because of their, as he put it, forward-looking language in the case where the deportation hasn't been put into effect. In other words, where the person has been removed. So that's his argument on statutory construction.
Yes, well, the response to that is that his construction is a perverse one for the reason Lord Justice Underhill gave, which is and I think the Upper Tribunal said about the revolving door falling off its bearings or something, because on my learned friend's case, this is forward-looking, so it applies before a person has been deported. So say this example, a person is subject to a deportation order. On the 30th of December 2024, they're still in the country, and all of these things apply. The Secretary of State then flies them back to their country of nationality on the 31st of December, and at that point, on that day, the moment they arrive, because they've already been deported, they can make an application for the deportation order to be revoked, and none of this applies, because on that construction, involves the only limit in that construction is nothing to do with 10 years. It's to do with once you've left, this doesn't apply. And that's the
Yeah.
perversity point picked up by this court in several cases.
But at that point, as I understood Mr. Symes's argument, because the statute doesn't apply, you go into the rules, and the rules do exactly the same in 398 and 391 for somebody who was either sentenced to more than 4 years, so that the 398 doesn't apply at all, or is within the 10 years. That's what I understood him to say.
Well, I'd understood his case to be that the rules don't apply either, because that he was relying on what Lord Justice Underhill said in VP,
To be construed the same way.
which was that the rules don't apply, so it leaves you with nothing.
He seems to be saying that paragraph, whichever it is, that talks about the case by case
391.
391, he seems to accept that 391 applies, but not that the other rules apply, I think. Is that
Yes.
right? He's not.
Indeed, yes.
Yeah.
Yes, and that is what Lord Justice Underhill said. He gave a provisional view on A398, which my Lady Justice Andrews picked up in argument. It was assumed to be correct in SU Pakistan, but without being decided by the court. We would submit, although nothing turns on it in this case, we would submit that those rules do apply. But so far as the tribunal is concerned, it's section 117C that applies. In our submission, the meaning of the legislation is clear, and it isn't an answer to the clear meaning of the legislation and the perversity point just made to say, well, don't worry about that because the rules will apply. Well, in that case, the rules could apply while a person is still here as well. The question is on its plain language, and looking at Parliament as a sensible legislative body which doesn't do strange and anonymous things, which of course is an accepted principle of statutory construction. Would Parliament, taking into account the broad language in section 117A and taking into account that the moment somebody left, a different set of principles should apply, would Parliament have done that? In our submission, it absolutely would not, because it would be perverse. And if it had intended to do that, it would have used clear language and said so.
Well, you see, I think you can say that one's got to look at 117C in the context of 117A.
Precisely.
And so if there's an obligation to have regard to the whole of 117, and you're right on the meaning of concerning deportation, then naturally that would embrace a decision by somebody to decide whether or not to revoke a deportation order. If one looks at subsection 7 of 117C, that does seem to be related specifically to a decision to deport somebody,
Yes.
rather than a decision to revoke a deportation. Well, if anything, it seems to me that strengthens your argument, because that's a case of Parliament using clear language to say that is a forward-looking provision. It is considering a decision to deport, not a decision to revoke, a decision to deport. However, when you come to subsection 6, all that happens is that person has been sentenced to a period of imprisonment of at least 4 years. The public interest requires deportation. Well, does that simply mean the public interest requires that they be removed from the country as soon as they've served their sentence? Or does it mean that they should be excluded from the country?
Yes.
Seems to me on any sensible reading it means the latter and not the former.
Precisely so. And if all one needs to do is read those provisions in line with the meaning of deportation in IT Jamaica. The public interest requires the maintenance of seized deportation.
Does that mean that exception 1 never applies once you've been deported?
No.
Well, it says there would be very significant obstacles to C's integration of the country to which C is proposed to be deported. How can you apply that if he's already been deported?
That's fair on the words proposed to be deported, but exception 1.
So you would have to read. You see, you've several times referred to the plain language of the statute.
Yes.
But I don't find that helpful, because I don't find this language at all readily transferable to the case where someone has already been deported. 4C plainly, as Mr. Symes submitted, is drafted as if someone has not yet been deported. Now, is it your submission that when someone has been deported and is seeking revocation, such as Mr. Nguyen, exception 1 can never apply because there is no longer a country to which it is proposed to be deported? Or is your submission that you have to read that as if it said into the country to which C is proposed to be deported or has been deported?
Yes, although one has to remember that that provision is likely to be less significant in a case like that, because what one's
Yeah,
doing.
But it's a question of what the language means.
Yes, but
one needs to get at that first.
Yes, although if one looks at that in context, the reality is if somebody's here, one has to look at, and based on the Article 8 case law, whether there would be very significant obstacles into the country to which they're proposed to be deported, because that's what the case law says. Once they're already there, they're there. So there isn't, and one of the cases, as your lordship would have seen, comments that there's nothing really in the Strasbourg jurisprudence that helps somebody in the appellant's position in this case.
None.
So to the extent that if somebody were to say, well, I know I've been here for a number of years, but actually I can't integrate here for those reasons, perhaps they could rely on that exception, but that's primarily going to be engaged in a case where somebody hasn't gone yet and they couldn't be integrated. It's going to be engaged. I'm not ruling out that it couldn't be engaged, and in those circumstances, yes, it could be read as saying has been deported, but I can't at the moment think of an obvious example.
No,
It's certainly not
I
this
can't
case.
I can't see any difficulty in saying exception 1 only applies prospectively, because that's what it says. And that's the situation in which only sensibly you would look at it, because you're looking at significant obstacles to integration and so forth. If you're seeking revocation, whether you're doing it within 10 years or anything else, you're not going to rely on significant obstacles to integration.
Yes.
You're going to rely on exception 2.
Yes, and of course, and I think this has also been pointed out in argument, and it features in the Supreme Court decision in Rupia, that overall these provisions must allow a good Article 8 claim to succeed. So whether or not it wouldn't matter if somebody on the language of exception 1 did or didn't satisfy it, because if there genuinely were a problem which one could describe as integration once they were gone, then they would succeed in any event under section 117, because the whole thing is intended to respect somebody's Article 8 rights, albeit giving weight to particular features of the public interest. So
I thought you said that in subsection 3, the words "the public interest requires C's deportation" mean the public interest requires C to be deported, and once deported to remain excluded.
Yes.
Well, how can you consistently, with 117C3, envisage a case which does not fall within exception 1 and exception 2, but still is required by Article 8? How does that fit in with
I'm not
statute?
First, the statute, because the statute is not simply the exceptions. As a whole, the way that this statute works is whether or not you fulfil one of those exceptions. If you have a good Article 8 case, and even taking into account the Secretary of State and Parliament's view as to how the balance should be struck between the public and the private interest, you will succeed under this provision, and that's Rupia. So in my submission, it doesn't actually matter whether or not a person could or could not rely on exception 1. I'm not ruling it out. I can't at the moment think of any circumstances where it would apply. But the point is, if there were a good Article 8 claim to do with some sort of obstacle in the country, that's not what that exception is intended to capture, as my Lady Justice Andrews said. But suppose there was something analogous, the person wouldn't need to rely on exception 1. They could come in under compelling circumstances on particular facts.
The whole point about the exceptions is that they are a shortcut to the success of your human rights appeal.
Precisely.
But they aren't an exhaustive statement of
Never
all the circumstances in which a
Precisely.
human rights appeal could succeed.
Yes, precisely. So the fact that the fact, if one's looking at the factors here in favour of my interpretation versus my learned friend's interpretation, I have loads on my side of the scales. All he has on his side of the scales is, well, exception 1 wouldn't apply, but that gets him nowhere, because exception 1 is an example of a case, an Article 8 case, where Parliament has decided, yep, in those circumstances we accept the public interest is against deportation. But the fact that that situation wouldn't arise if somebody has already been deported really doesn't affect the analysis.
So when subsection 3 says, in the case of a foreign criminal, etc., the public interest requires deportation unless exception 1 or exception 2 applies, that public interest can still be outweighed by other considerations.
Yes, that's why we have section 117C6, and
that doesn't apply to someone who's been sentenced to less than 4 years.
it
Yeah,
does.
the case law says it
Yes,
does.
it does. So yes, and in fairness, and in much politer words than probably I would use, this court has said on many occasions it's not an example of marvellous drafting. I can't remember how Lord Justice Underhill put it, but characteristically beautifully.
Infelicitous, I think, was one word. he's used.
One word. So the way that it works is that if you're what's called a medium offender, if you don't satisfy the exceptions, you can also still come in under section 117C6, because otherwise that's just the way that this has been interpreted, and obviously rightly so, because otherwise more serious offenders would be in a better position.
And it would be the same under the rules, wouldn't it? You know, very compelling. You can always ask if the rules say, well, there's an assumption that you can get in if you tick this box and that box. You see it with exceptions 1 and 2 and the children and that sort of thing. Paragraphs, what is it? ADE 1, ADE 2, all of those.
Yes.
That whole line of.
Yes, that's
What's
right.
it's a decision of, I think the judgment was given by, goodness me, I'm trying to remember, was it Lord Justice Jackson? The case that says that 117C6 applies.
Yes,
something or other.
It is. Yes, I don't. It might.
The name of it.
The MF. I can't remember, but I can find out.
Yeah.
But yes, it's absolutely and well established.
Yeah. And I think there are dicta in the Supreme Court to that effect as well.
There are, yes.
It might be helpful for us if you could maybe just point in a direction or two.
We'll just do a little shopping list at the end. I've spoken to my learned friend, and we will get something to the court on some of these points.
Is it NA Pakistan?
NA Pakistan. Have we got it in the bundle? No, we got it. We haven't got it in the bundle.
Jackson's nodding behind.
It's probably cited. There are lots of cases on Article 8.
It's licensed in CI Nigeria.
I think a lot is classic.
CI, we have CI Nigeria. Which packet number?
Paragraph 93.
So I'm just turning up. So page 306. Yes, perfect. I'm very grateful to Miss Jackson. Page 306 is CI Nigeria, and that cites Lord Justice Jackson in NA Pakistan.
Yes, isn't it?
It might not be precisely the relevant passage in that case, but that is the case.
Yeah, that's really helpful, thank you.
So essentially that's what we say about construction. We say it's straightforward, and
just before you
yes,
leave that, you said that it was all that Mr. Symes had was that exception 1.
I'm so sorry, I didn't hear your lordship.
You said all that Mr. Symes had was that exception 1 didn't apply once you'd been deported. But he also relied on exception 2. He said that was forward-looking as well. The effect of seized deportation would be unduly harsh. And do you accept, I'm trying to get at what the language means, do you accept that he's right about that, but that too is forward-looking, or do you say that's another case where the word deportation should be understood as meaning not only the act of deporting, but the maintenance of exclusion.
Yes, because unless Parliament is to have legislated for the perverse consequences that I described, which is on 30th of December, it has to be unduly harsh, and on the 31st, when you're in a different country, it doesn't, and you can come straight back, all other things being equal. Absolutely, yes, it's simply read in that way. And nobody's suggested in this case, indeed, that's how the Upper Tribunal applied it, and that's a sensible construction.
But even if that exception is forward-looking, one falls back on very compelling circumstances above and beyond the two exceptions, and that's a broad textured test.
Yes.
I always thought would be unduly harsh is a test that you apply when you're making the decision as to whether or not your Article 8 rights are infringed.
It is, but
So it's talking about the present state of affairs, and that doesn't depend on whether you're about to send somebody away or let them back in.
yes, that's right. Your ladyship makes a good point, because at the point that you're saying to the Secretary of State, let me back in, you're saying it would be unduly harsh not to do that.
Correct.
Yes, but it still raises the question of what's meant by deportation.
Well, that we say Lady Justice Arden was right.
Your submission is that deportation, not only in section 117A 2B, but in 117C 1, 2, 3, 5 and 6 means not just the act of deporting, but the maintenance of someone's exclusion.
Precisely, because deportation isn't just a one-off act, and indeed when a deportation served, it's given without time limit. Your Lordship can see the deportation order in this case. It says it says
It doesn't say 10 years.
no, it doesn't. It says you need to leave and you can't come back again. So could I just, perhaps it's helpful just to have a look at that.
Well, that's why you need to revoke it. If it just said you can't come back for 10 years, then you wouldn't need to revoke it.
Quite, but a deportation order, if the court looks at 171 of the core bundle as to what it actually does, it doesn't just say leave. It says we prohibit you from entering the UK so long as this order is in force, which obviously lends substantial weight to my submission that deportation order doesn't simply mean off you go. It means don't come back.
Yeah, it's an
Well,
order.
that's what the 71 Act, section 5 of the 71 Act says.
Yes.
That's what a deportation order is.
Precisely, and this, in my submission, the 2014 Act, which is legislation specifically concerning immigration, has to be read in line with what a deportation order actually does, and indeed, as your Lordship rightly points out, section 5. Requiring him to leave and prohibiting him from entering. That's what a deportation order is under primary legislation. So again, if Parliament had intended to mean something else, just mean this only applies at the point that somebody leaves, it would have said so in my submission.
Yeah, so in other words, it's not just a one-off decision.
No,
It's an order that continues and has a continuing effect.
Yes, and my Lord Justice Nugee makes a much better point than me by going to section 5.1 rather than the deport order, which of course reflects the legislation. But that is what a deportation order is, and that is what Parliament has in contemplation when it makes the 2014 Act. And indeed, reading the 2014 Act, both with section 82 and also with section 5, gives coherence to the statutory provisions as a whole, which of course is another principle of statutory construction. So it really, in my submission, leaves my friend with very little indeed, and hardly surprising that the courts have proceeded on the basis that they have.
So if I've understood your submissions correctly, deportation means not just the act of deporting, but the continued exclusion of the deportee.
Yes.
Except that exception 1 does not in terms apply once you've been deported, because that is contemplating a country to which you are to be deported.
Yes.
But if there were a case where it was impossible for a deportee, there were very serious, significant obstacles for a deportee to integrate into a country to which he had been deported, well, it wouldn't technically come within exception 1, you could rely on it as very compelling circumstances under subsection 6.
Yes.
As a medium offender, even though subsection 6 doesn't refer to me.
Yes, precisely so. So either you can do it in two ways. Either you can read exception 1 broadly, or you can do it by bringing the person in under section 117C6, because your lordship's question about, well, hold on, how does a medium offender rely on section 117C6 illustrates that the Court of Appeal in I've forgotten, it's NA, isn't it? My mind is bursting with cases. Has that this language hasn't been read literally. So you could read exception 1 to cover that situation if you needed, but you wouldn't need to because you've got the catch-all in section 117C6. So there really is, in my submission,
Well, I think I wouldn't endorse your use of the word plain language, but I think I now understand how you invite the court to construe the language.
yes, well,
Curate's age, plain parts.
so be it.
Yes, thank you.
Certainly I say that section 117A on any view, and particularly section 117A is clear and plain. But in any event, it doesn't matter, it's quibbling with language, because overall if one takes a step back, looks at the purpose, looks at the language as a whole, looks at other statutory provisions, it's clear in my submission on the basis of that exercise what the right interpretation is, even if individual words are not themselves plain.
Part and parcel of the one section, of course, I mustn't forget that.
Precisely.
And then, if I've understood it correctly, if you're right about that, then until the rules were replaced relatively recently, so for many years, from 2014 till 2022, the rules appear to contemplate medium offenders would be treated differently after the expiry of 10 years.
Yes.
You say there's nothing in the statute which not only directs that to be done, but enables it to be done. There's nothing there.
Well, because the statute's dealing with human rights,
Yeah.
and it's open to the Secretary of State to revoke on the basis other than human rights. So, for example, somebody, and perhaps is that a good moment to turn up the rules, because that's what we say that they do. So the rules, the 2022 rules are at page 59, and I hope this will answer your lordship's question. So what 391 does, and that's on page 62. Remember that these rules aren't only about human rights, but they deal with human rights as well. What 391 does is give the Secretary of State a discretion to revoke a deportation order on a case-by-case basis where 10 years have elapsed. And she can do that whether or not there is a breach of human rights.
So you can simply do it on compassionate grounds.
Could do, yes.
Classic case usually being somebody suffering from a terminal illness or something of that nature.
Something like that.
It
would- Yes, and one can think of examples where, for example, a very short visit or something very compelling, which doesn't engage Article 8 at all because it's nothing to do with family life, and the person's not had a private life here for many years, but perhaps they've won a very special prize or were coming to give a talk or something like that. But in those circumstances, they wouldn't have an ECHR right to do it, but the Secretary of State could revoke the deportation order. Now,
And section 117 is limited to where a court's or tribunal's
Precisely.
considering
So if somebody wants to complain that the Secretary of State hasn't revoked their deportation order under 391, and this is partly why the first tier goes so wrong, if somebody wants to complain about that and they can't mount a human rights claim, then they don't have a right of appeal. The Secretary of State hasn't refused a human rights claim. They need to bring a judicial review.
Yes.
And the tribunals, 2 points to make about the tribunals. A, they don't have jurisdiction to deal with it in the human rights appeal, because all that they can determine, because the rights of appeal were restricted, is the refusal of the human rights claim. So if there isn't one, then the person can't complain about it in the tribunal. The only way that it can come into the tribunal is if the person were able to say, perhaps, the Secretary of State's decision is so bad and so wrong somehow perhaps it's not in accordance with the
Yeah.
law, but that's going to be very difficult for somebody to argue. They would need to bring a judicial review if they want to challenge that sort of exercise or lack of exercise of discretion in their favour.
I'm trying to remember, but a few months ago I was sitting on an appeal where precisely this rule, and it was a chap who'd been deported as a foreign criminal. His wife had terminal cancer, and I can't now, off the top of my head, remember. I mean, sadly, by the time the appeal reached us, she died, and so it all became academic. But I can't remember whether they went down the JR route or whether they went under the very compelling circumstances. But it was definitely an example of a case where it wouldn't necessarily have got home under Article 8.
And that we say is one of the reasons why the first year goes badly wrong, because what it does is convert the ability for the Secretary of State to decide on a discretionary basis whether or not to grant, or to revoke a deportation order other than on human rights grounds, and make that a human right. As we read the decision, and that's simply wrong as a matter of law. But in any event,
Does that submission depend upon the section 117C point? I understand if you're right on 117C, then the tribunal can't decide a human rights appeal except in accordance with the structure set out in Part 5. But if you're wrong on 117C, what does the tribunal do?
Well, but that, in a sense, that strengthens my point, because it means that Parliament has left the tribunal without any guidance as to how to deal with the human rights claim and what weight to give to particular factors. The tribunal would still, I suppose, if Section 117C doesn't apply, would still need to look at the rules for the Secretary of State's policy, would still need to look at the Secretary of State's decision for the Secretary of State's policy, because Ali says it's not just the rules that show the Secretary of State's policy, it's also the decision, and determine the human rights claim on that basis. And in my submission, there would be no human rights imperative which would allow the person to succeed in those circumstances unless they had a compelling human rights claim. So it in my submission, it means the tribunal is still wrong. Because if Section 117C doesn't apply, it's still deciding whether or not there was a breach of Section 6 of the Human Rights Act 1998, because that's the ground of appeal. So and
that's the only permissible ground.
That's the only permissible ground. So it's back into looking at Strasbourg case law, but we know from, I think it was SU says, well, there's nothing really in the Strasbourg case law that helps the appellant. It's back in Strasbourg case law and looking at the Secretary of State's policy in the rules, which really, in my submission, would have the same result. But of course, our submission is 117C doesn't apply, but you end up at the same place in my submission. What the tribunal can't do is say, well, there's a discretion for the Secretary of State to revoke the deportation order, and I think in this case she should have done it. That's A, it's beyond the jurisdictional ground, and B, even if the tribunal were entitled to hear a judicial review, that wouldn't be good grounds for allowing a judicial review, because it's the Secretary of State's discretion.
And it can't be said it was exercised perversely.
So all roads lead to the same outcome, but all of that in my submission strengthens my point. This is clearly what Parliament intended, because otherwise things start to fall apart and not make sense, quite apart from all the other factors. On the rules, for completeness, that the court has seen an earlier version of these rules which didn't have the words that there needed to be consideration on a case-by-case basis as to whether the deportation order should be maintained, and that was introduced in October 2014, and the court's got that version at tab 7. We don't need to turn it up. So even at that point, there was a making more strict, if you like. That wasn't the version considered by Lord Justice Underhill and Lady Justice Arden, but the Secretary of State changed the rules to make clear that there would then be consideration on a case-by-case basis, rather than you would just automatically get it if 10 years had elapsed. And then what we see in the rules now is nothing about 10 years. So that has now gone, and so far as if the Upper Tribunal were to remake this decision, and it were looking at rules rather than looking at section 117, it has to look at the version of the rules which doesn't have any reference to 10 years.
And I think the Upper Tribunal did advert to that at some point in making decisions. Didn't they? I think they referred somewhere to.
I can't now recall. Certainly we've made reference to it at the end of our skeleton in the very last paragraph. But I can't.
Paragraph 49.
Yes, that's right.
So they say current version.
Yes.
No difference in outcome.
Yes.
Apply.
Yes, and we then pick that up and support that in our skeleton at the end. And it rather goes to show that the rules can't dictate the meaning of the statute in terms of 10 years, because the meaning of the statute would keep changing every time the Secretary of State changed the rules, which of course it doesn't. Just for the court to know, I'd said earlier that the case law of this court more generally is that tribunals don't, where section 117 applies, and I appreciate that's contested here, but where it does apply, tribunals don't need to worry about the immigration rules, and that's CI Nigeria at page 287 of the authorities bundle, paragraph 21. 288, I'm sorry. Top of page 288. And the reason, I should have said, to understand why there's no need to do it, one needs to read paragraph 20, because it's all taken care of by part 5A, effectively. So that was all I was proposing to say about the rules. I was then just going to deal with the case law, bearing in mind, of course, that Mr. Symes has very fairly taken you to most of it. And in one case, he didn't take you to a case called Benaku, but that was by accident. And I'm content for him to deal with it in reply. He meant to. I think was slightly put off by the questions. It's very easy to be diverted from one's course. So I certainly don't criticise him for that. So far as I can take these fairly briskly, the court has seen ZP India, and the court is aware that Lord Justice Underhill was dealing with a different version of the rules without those additional words about case by case. And it's right, again, just to acknowledge, as my learned friend said, that certainly Lord Justice Underhill proceeds on the basis that paragraphs 398 of the immigration rules and 399 don't apply in a person already left deportation case, and albeit obiter, he doesn't think that A398 makes any difference. That's assumed to be correct in SU Pakistan, but it's not expressly considered. So I'm not proposing to deal with ZP India, other than to just invite the court to note that on page 114 at paragraph 24 is that Lord Justice Underhill's construction of the rules is that where, and I'm just, it's probably useful to have one's finger in the 2020 rules at the same time. that, so what the court will recall.
So sorry, can you just remind us which page?
Yes, the bit that we were looking at in the 2022 rules was page 62.
Yeah.
And then at the bottom of page 62, what we see is that the Secretary of State, she's got the discretion to revoke that I described, which doesn't require an ECHR breach. And then she's mandated to continue it unless, and this is the bottom 3 lines of page 62, unless the continuation would be contrary to the Human Rights Convention, or there are other exceptional circumstances that mean the continuation is outweighed by compelling factors. Lord Justice Underhill in VP says, sorry, ZP, I think I've been calling it VP. Lord Justice Underhill says both of those are about human rights. And that's in paragraph 24. He says, and while the use in the sweep-up exception of the phrase other exceptional circumstances involving compelling factors no doubt implies that it's only in such circumstances that the Secretary of State's general policy will be displaced by Article 8. So that's why for people under 10 years, it's different because they don't need to establish an ECHR breach. But for the reasons that we've canvassed, the solution or the remedy to that is not to go to the tribunal. So I don't need to deal with ZP India. I've kept mentioning IT Jamaica without turning it up, but the court's already seen it, so I'm not proposing to take time on that. I just want to make this point to be clear about when the court is and isn't bound. And could I, and I apologise for this, but just for completeness, and I've shown my learned friend hand up the Dean case, because it may be important in this context. Now, the court may well be familiar with this or the case which it cites. Please ignore, oh no, yours won't have pagination at the bottom. Apologies. Could I just invite the court to read paragraphs 29 to 31?
If the point wasn't the subject of argument, it wasn't, or was the subject of a concession, then strictly speaking, even if it's part of the ratio, we're not bound by it, is that it?
Yes, but one has to be cautious when saying there hasn't been argument on the point because of the qualification in that Kadeen case at the bottom there, indented paragraph 38. There may, of course, be cases, perhaps many cases, where a point has not been the subject of argument, but scrutiny of the judgment indicates that the court's acceptance of the point went beyond mere assumption, and we say that's true of IT Jamaica. In any event, we submit this case doesn't need to turn on that because Lady Justice Arden was clearly right, but we submit what she says about deportation is her own decision given after proper consideration. SU Pakistan, the last point to make about IT Jamaica is that the Supreme Court also proceeds on the basis that section 117 applied in that case, except it wasn't argued there. Just a point to make in general about ZP India and IT Jamaica is that they talk about the prescribed period. What the Court of Appeal is doing is giving weight to the Secretary of State's policy as it was then expressed in the rules. But of course it's changed since then. It's changed in the respect I identified by saying case by case, and it's changed since in not having a 10-year period at all. So in that sense, those cases are of limited assistance because they deal with a different part of the rules. I've addressed, and I'm giving you the cases in chronological order. So it goes ZP India, IT Jamaica, SU Pakistan. The court has seen that. I can't now recall, and apologies, if you were asked to read paragraph 64 of SU Pakistan. It's on page 218. Can you remember? Okay, thank you. Could I just invite the court for completeness, because you've seen SU Pakistan, just to read paragraph 64 on page 218. And it's right to say, I think that this is obiter, yes, but nonetheless important. The next case in time is Williams in the Upper Tribunal Presidential Panel, which you've seen we rely on that reasoning. I don't need to take the court back to it, but we do rely on it. EYF Turkey, again, the court has seen that, and as I mentioned earlier on today, we can't explain why the 2014 Act isn't addressed, and see paragraph 72 of our skeleton on that. But insofar as the reasoning goes, addressed to the provisions of the rules and human rights, and the ability to return, we do rely on the reasoning in EYF Turkey. And I wasn't proposing to say any more about EYF Turkey than that. The court has seen the key reasoning. It's at paragraphs 25 and 26. Up to 28. Now, the next case in time is another decision of a presidential panel of the Upper Tribunal, and that's Benaku at tab 28, which I know Mr. Symes meant to take you to. It's fair to say that in this case, the relevant propositions were agreed between very experienced counsel for the appellant, Mr. Malik, and the Secretary of State's presenting officer. But it is important just to look at this case. The facts from the head note, page 457, it's a revocation case, but it is one where somebody had sneaked back in rather than one where they were trying to apply from abroad. So the key facts, just invite the court to read those at the top of page 457 in the head note. A big chunk of this case is about a procedural issue which we don't need to worry about here. Certainly not the same procedural issue anyway, we have our own. And then page 473 onwards, one can see the Secretary of State submission, and then that they were agreed to by Mr. Malik, now Mr. Malik KC, acting for the appellant. And then the tribunal also deals at paragraph 73 with the Secretary of State submissions on section 117C7, and then the tribunal considers it for itself, but of course this court isn't bound by this tribunal, but we say it's right. Paragraph 76, the collective position on the parties of the substantive issue is essentially correct, and then it gives its reasons, and the reasons are that essentially not dissimilar to the submissions I've made today. I don't, I think, need to ask the court to read it now. It's supportive of my case. Paragraph, the passages are sidelined, and paragraph 81 decides expressly, in the context of construing and applying Part 5A, we see no reason in principle as to why the re-entry scenario should not be considered as much a part of what was described in Williams as the deportation regime, as removal action and exclusion from this country during the currency of a deportation order. And in fact, they interpret even the phrase decision to deport a foreign criminal accordingly. We don't need to go that far. But, and then again at paragraph 88, ULA is SU, and they decide section 117C applies equally to all three aspects of the deportation regime. And then finally, again, paragraph 91 is sidelined. They summarise their conclusions. So Benarku very much supports the Secretary of State's position here, and obviously we say entitled to be given considerable weight because it's a decision of a presidential panel. The final case I wanted to show the court is a recent decision of this court, handed down on the 26th of September, and that is on page 406, tab 25. Now, before we go here, I'm not suggesting it answers the question about section 117C, but it is a decision I think that the court needs to see. It certainly decides that section 117B applies. So the facts are that paragraph 7, there was a deportation order signed in 2002, which was enforced in 2002. And then paragraph 12, like this case, many years later in 2020, there is an application to revoke the deportation order. The reason for the underpinning Article 8 claim is summarised in paragraph 18, and it's right to say, if one reads the facts of this case, that the facts are fairly exceptional. It's to do with the health both of the parents and the children, and the reasons given by the first tier tribunal, and I don't need to show the court those now, but they appear up to paragraph 51, and probably the nub of it is at paragraphs 50 and 51, is the nub of the first tier's decision. So there are 4 grounds of appeal. They are at paragraphs 55 to 58. Spoiler alert, the fourth but not the others succeed. Paragraph 61, the court refers to section 117A2 and proceeds on the basis that all of section 117 applies. It's right to say that it wasn't argued to the contrary in that case, although in this case I should say that the respondent, was in person. But certainly the court proceeds on the basis that section 117, all of section 117A to D apply. And then paragraph 82 neatly captures the point that where there's a medium offender taken from NA Pakistan, and there wasn't any dispute, as paragraph 82, that the respondent's circumstances didn't fall with any of the exceptions. Therefore, the FTT was only entitled to answer the public interest question in the respondent's favour if there were very compelling circumstances. This is a medium offender case, so it's an example of NA Pakistan in action. And then the court summarises the approach where a person is relying on very compelling circumstances, nothing complicated or unusual about that. Paragraphs 89 and 91. At paragraph 92, the court captures the public interest that, and this comes from Lord Wilson in Ali, although recently Lord Hamblin in HA Iraq has said, well, is that completely right, but didn't decide it. But what Lord Wilson says in Ali, and for the court to note, it's paragraph 69 of Ali, is that there's more to the public interest in the deportation of foreign criminals than just public protection. There's also the issue of deterrence and public concern. So that's just captured there in paragraph 92, not an issue for this court at this point. And then paragraphs 97 to 98 specifically address section 117B in the context of revocation. Now, until we got here today, I hadn't realised that it was accepted that section 117B applies. We say it's certainly part of the ratio of cap that section 117B applies in a revocation of deportation case, because it's essential to the reasoning on ground 4, which the court finds to be made out. What I can't say is, I suspect, because the court may simply have assumed the correctness because it doesn't record any submissions having been made to the contrary. That ground succeeds effectively because the first tier tribunal goes wrong on the public interest. It's right to say, and again, I accept it's not an issue particularly in this case, but in the case of Yalsing, which is a decision of Lord Justice Underhill, and the court has that at page 381, but in a nutshell, what Lord Justice Underhill says is the tribunal can't come up with its own public interest factors, because that's for Parliament and the Secretary of State, so nothing controversial about that. We say, in this case, what the first tier tribunal did actually, quite apart from getting section 117C wrong, it also says, well, I think it's better that you let people back after a short time because that will make people comply with their deportation orders. That's not for a tribunal, and that's precisely why Parliament enacted section 117, because the Secretary of State has a different view as to what the public interest requires. So the first tier tribunal in our submission shouldn't have done what it did, which was to make up its own reasons as to why the public interest required that people come back. I'm straying into ground 2. Sorry, but just to make that point, because it's linked to what the court decided in CAP. So those are all the cases I was going to go to, and we say it's absolutely clear from the legislation and the case law that ground 1 is wrong. I've already, I think, dealt with the argument taken against us that relies on the rules to dictate the interpretation of section 117. I won't repeat those points. As to the argument that the public interest in deportation is diminished after a lengthy period, and this does take me into straying also into ground 2, we say that the weight to be attached to competing considerations, well established, falls within the margin of appreciation of the national authorities. See Ali at 35. and we say that the words of the legislation are clear in this case in relation to the public interest question. And they certainly do not provide that it's diminished after a particular length of period has expired. What they require is compelling circumstances. Now, it's clear when one looks at the case of CAP that I just referred to, that the reason that this court upholds that decision is because the circumstances are compelling when one reads the facts in more detail. But that's what the legislation requires, compelling circumstances. Also simply addressing, I think my learned friend called it a policy argument, that the public interest in deportation is diminished after a lengthy period. The appellate authorities have obviously got to give weight to the Secretary of State's assessment of the public interest expressed in both the rules and the decision letter. And for the court to note, the decision letter does deal with those at paragraphs 40 and 45 at page 167 of the core bundle. We don't need to turn it up, but the Secretary of State certainly turns her mind to those things. So where we end up then is this, that the interpretation of the legislation is clear, and the appellant has to either bring himself within an exception or within very compelling circumstances. And very compelling circumstances means, in the case of revocation, what it means in other cases. It doesn't have a different statutory meaning. We accept, of course, that when considering the very compelling circumstances test, all the facts have to be weighed into the mix. We accept that. That's what H.A. Iraq says. See paragraphs 54 to 59. But the fact here is that there's really very little on the appellant's side of the scales, and I won't repeat the points that were made in argument, but even the first tier tribunal says, well, I can't remember his exact words, but pretty much along the lines of, well, this just isn't a compelling case.
Yes, because I think the FT tribe, the first tier tribunal finds that it's not unduly harsh on our scenario, and there aren't circumstances.
Yes, exactly. So my learned friend can't have it both ways. He can't have bits of the first tier's decision upheld and bits of it not. That the outcome for him, if Section 117C applies, is that he fails. If Section 117C applies, the first tier tribunal's decision simply can't stand because it didn't apply it. But if there were some legal possibility of going through a first instance judgment and seeing if you could jigsaw bits of it together and make it work, which we submit there isn't, but if you could do that, he still fails because the first tier tribunal on the correct test says there's no compelling circumstances. I'm just finding the passage. But my learned friend very fairly took you to that. Oh, none of this is very compelling. Well, that's really the end of it. If the first tier decision stands, he still loses. So really, I think I've addressed ground 2. For the court's note, it's also addressed in our skeleton at paragraphs 79 to 88. We say that the complaint about the Upper Tribunal's remaking decision is effectively complaining about weight given to various factors and the outcome. But there isn't an error of law. The tribunal directs itself correctly. It has due regard to all the relevant matters and it reaches a conclusion reasonably open to it. It's just that the appellant doesn't like it. Just for the court's note, lack of reoffending, and perhaps we could just turn up H.A. Iraq rather than continue listening to my voice. In relation to lack of reoffending, H.A. Iraq begins at 347. Paragraph 55, page 365, paragraph 55 at B, there's a citation from a decision of the Upper Tribunal which makes the fair point that the fact that an individual hasn't committed further offences is highly unlikely to have a material bearing, given that everyone is expected not to commit crime. Lord Hamden then refers to Bimbuga, which is a case of the Court of Appeal where he cited and agreed with that passage, and then he refers at 57 to a different Court of Appeal which said, well, rehabilitation is in fact relevant, and he reaches his conclusion at paragraph 58. Effectively, he says the weight is limited, and could I just invite the court to read 58? And then at paragraph 59, there's the concern about what Lord Wilson said in Ali, but again, that isn't an issue in this case. Just out of fairness, there it is. So I think at one point my learned friend said that the Secretary of State was steamrolling. The Secretary of State accepts that a very compelling circumstances analysis is a matter for the fact-finding tribunal, and it has to be done on the basis of the facts. But what the court says is no definitive statement can be made as to what amount of weight should or shouldn't be given to any particular factor. It depends on the facts and circumstances. What is clear from this decision is that not having reoffended is not a weighty factor in the mix. And similarly, we would submit by parity of reasoning, having complied with a deportation order is, as the Upper Tribunal said, not a very weighty factor in the mix, because you should be doing that anyway. Just for completeness, in relation to seriousness of the offence, could I just invite the court to read paragraph 70, because it's not right to say that it's never relevant. So with that then, just to look quickly then at the Upper Tribunal's decision, the remaking decision, which is at page 89 of the core bundle. Now it can't, starting at page 98, the tribunal, paragraph 28 and 31, is well aware of the facts, so it can't be said it didn't take into account something relevant on the facts. And then at paragraphs 34 to 40, it decides that the unduly harsh threshold has not been met. There's no challenge to that conclusion, nor could there be. That, in my submission, is not a promising basis on which then to argue that it went wrong in relation to very compelling circumstances. And then if one looks at the tribunal's analysis of very compelling circumstances, which begins at paragraph 41, it correctly directs itself that it's a difficult test to satisfy, no complaint about that. And then it says, in undertaking my assessment, I've taken account of all the circumstances. I will now address what I consider to be the relevant considerations. And of course, I don't need to remind this court that when reading decisions of expert tribunals, which in my submission, in relation to a remaking decision the Upper Tribunal is, it's right to proceed on the basis that it knew what it was doing. So, paragraph 42, deportation is in the public interest. Paragraph 43 takes into account relevant lengthy separation, says it's relevant and carries some weight, but the weight is limited in this case. Nothing wrong with that. And takes account of what the conclusions on unduly harsh and the fact that there have been numerous visits to Vietnam and other countries. Paragraph 44 makes the fair comment in my submission that accepting the consequences of a deportation order is not something which ought to give particular brownie points. What he says is it doesn't attract very much weight, but he gives it some weight, but certainly not a very compelling circumstance. Again, we say nothing wrong with that.
In keeping with the case law you've been showing us.
Quite. He then, paragraph 45, makes the fair comment that deportation is in the public interest also as a matter of immigration control, and that's accepted in one of the Supreme Court cases. So he's not attaching material weight to the contention that the maintenance of the deportation order constitutes punishment. He then makes the point that maintenance isn't an indefinite state of affairs. There's a revocation process, albeit one that involves stringent tests. I place no weight that it'll always be precluded. Well, that's right, for two reasons. One, because the Secretary of State has a discretion which is unconnected to human rights. And second, because if there is a good human rights case, she's required to revoke. So he's right, he can't proceed on the basis that it's indefinite because this person's circumstances may change, in which case that there's a route for them to be readmitted. So there's nothing wrong with that. Then paragraph 47, suitability requirement is highly relevant. Of course it is, because he's subject to a deportation order. And then at paragraph 48, the tribunal makes the point that it's, and I've shown the court the case law, it's part 5A which governs the process, not the rules. So the rules don't help him. But in any event, paragraph 49, the rules essentially reflect what the legislation says. Paragraph 50, he deals with low risk of reoffending and accepts that that to some extent is to his credit. However, it's only one consideration among a number. So he also gives weight to deterrence and public confidence. The absence of any offending in Vietnam is to be expected, but he attaches some weight to it, completely consistent with what I've shown the court just now in HA Iraq. Acknowledges genuine remorse, but says it adds nothing of real substance. Fair. Also takes account of the rights of the appellant's adult son and his grandchild, and goes into that in some detail. But decides, having considered those facts very carefully, that it isn't a very compelling circumstances, looks at a lack of health consideration, says the guidance on revocation doesn't take matters any further, and also at paragraph 55 says, although I don't place weight on it, Judge Brannan took the view that the circumstances of Appeal 1 were not very compelling. So if he'd applied the right legal framework, Benaku, then he wouldn't have allowed the appeal. And we say that that's right. So that really, in our submission, puts paid to somehow reviving the first tier tribunal decision if my learned friend is wrong about the application of section 117A to D. And having considered all of those factors, paragraph 56, the tribunal says he's unable to demonstrate that they're very compelling circumstances. he's got sympathy with him, but I have to apply the facts to the appropriate legal framework. In our submission, the Upper Tribunal has done absolutely nothing wrong. It's a clear and comprehensive consideration of this appellant's human rights claim, and rightly it fails. There is no error of law of any kind. So that then deals with ground 2, and we say that both of those grounds should be dismissed. It's going to be Miss Jackson's turn. Everybody will be pleased to hear shortly. I'm just going to turn my back and see if I need to cover anything else. Yes, I've dealt with all of the points. So unless the court has any questions for me on grounds 1 and 2, I'm going to hand over to Miss Jackson.
Thank you. Ms. Mythe's also kindly dealt with most of the points I had to deal with as well, so it just falls to me to explain how they apply to ground 3. The appellant's ground 3 is, of course, that the appellant, by virtue of being found by the first tier tribunal to have met the requirements of the immigration rules, therefore automatically ought to be taken to have satisfied the section 117C criteria and be found to have met very compelling circumstances, such that the Upper Tribunal ought to have allowed his appeal on that basis. Ms. Mythe's already explained why we shouldn't necessarily get into the territory of trying to preserve the FTT's findings in the event that the Upper Tribunal was correct in the error of law decision. But I will just answer this ground on its face, and the Secretary of State's submission is that this ground is wrong, broadly for 2 reasons. The first is the reason that Ms. Mythe has already explained in relation to the operation of paragraph 391 of the immigration rules, and that is to explain that paragraph 391 essentially reflects the Secretary of State's discretion to revoke a deportation order in circumstances where there isn't a human rights and ECHR reason why she must. And therefore what we're dealing with at paragraph 391 is a discretion under the rules. And what the first tier tribunal does with that discretion is convert that essentially into a requirement that it makes the finding in accordance with its interpretation of the rules. And that's not the correct approach. It is not what TZ Pakistan requires, that a discretion in the immigration rules becomes the basis upon which a tribunal must make a finding. And as Ms. Smythe has already explained, this is a case where the grounds of appeal are human rights grounds of appeal, so we're not in a territory where there's a right of appeal on the basis that the immigration rules have been inconsistently applied. So for those reasons, that there would be no right of appeal on the basis of 391 and the first tier tribunal's approach by essentially converting what the rules say in the first tier tribunal's interpretation. Obviously Ms. Mythe has shown that we consider that to be wrong, but converting that into an outcome on a human rights appeal is simply wrong in principle. So that's the first reason why we say ground 3 must fail. And the second reason is related to the substance of the findings, and it's as simple as that's just not what the first tier tribunal said, and the court's already seen the relevant passages of the judgment, and I don't propose to go through that at any length, but it is in my submission really quite clear from the face of the first tier tribunal's decision. So I'm looking in particular at paragraphs 50 and 51, where we see that the first tier tribunal, rather than following the approach in HA Iraq and that is reflected in section 117C, as Ms. Smythe has outlined, went to establish its own interpretation of what the public interest must be. It's clearly not what section 117C requires. It then continues to weigh its own public interest against the factors in the case, and obviously the court has already seen paragraph 56, which in turn says none of this is very compelling and finds that the appellant's treatment has not been unduly harsh within the meaning of section 117C. So in my submission, if it is the case that section 117C does apply to the appeal, it is really quite hard to say that the FTT actually did apply those provisions, or had it applied those provisions, it would have found that the very compelling circumstances test was met. It simply didn't. So unless I can assist further on ground 3, that's all I had to say about it.
Thank you very much indeed.
Thank you.
Can you reply, Mr. Symes?
Oh yeah, just briefly. So one of my learned friends' first points on the initial points on the first round of appeal was in relation to the possible defects in the FTT Judge Branham decision, and her point was that given that Section 117B is accepted as applying to all species of revocation decision, there was an overt error by the FTT in not dealing with that. So one point I'd make on that is that the post-it note point, as it was, which now we've had clarified, raised Article 8 and choice of residence generally, if then wants to establish a drafted pleading in the ground to appeal to the Upper Tribunal. In my submission, that is not a point apt to comprehend Section 117B. It's a general point about the scope of Article 8, but not one clearly invoking the elevated statutory thresholds. Secondly, in answering that point, I'd say that Ms. Smythe referred to Robinson, in that, as I say, even if it wasn't properly pleaded, could it be raised anyway? Now, of course, Robinson is a decision that originally arose in the context of refugee convention points being relied on by appellants and so forth. Its most recent expression, and no doubt the principle has expanded over time, is in the case of SA 2025 EWCA Civ 357, SA 2025 EWCA Civ 357, at paragraph 45, where judge says, the judge says, I do accept, however, that since the underlying justification for allowing a strongly arguable point to be raised by the tribunal of his own motion is to ensure compliance by the state with its international obligations, it must include all situations in which a point identified in the court or tribunal gives rise to a real danger of the state, recognising someone who does not qualify for international protection as being so entitled, etc. So what I'd emphasise is that, generally speaking, Robinson is seen as a pro-applicant principle.
I think I've given a judgment about Robinson as well.
But there's quite a few.
It rings a vague bell. I mean, it's a principle, but as I understand it, it's a principle that's narrowly confined to cases that involve compliance with the UK with its international obligations under the Refugee Convention.
It's not confined to applicants only, though. I think it's respondents and applicants.
But I think the circumstances in which it's being applied in favour of the Secretary of State are pretty limited.
Indeed, that was my point here really. This is a situation where, in the first place, the government has limited the scope of Article 8 in some respects by introducing the Part 5A regime, and then, in the course of this case, didn't manage to plead it clearly. In my submission, this is not a situation where the court should allow Robinson to permit in that point, but it was so vaguely put in the first place. Final observation.
Even if the effect of not allowing it would be a breach of effectively not applying Article 8 properly.
Well, not applying Article 8 properly as the government sees it. That's right.
That's my understanding. It's a principle operates in favour of the appellant generally.
Well, indeed, that's right.
Not
That's my first
exclusively, not exclusively, but it is a very narrow principle, as my lady says, when it applies in favour of the respondent. I think that the underlying rationale is that one shouldn't find oneself in a situation, whichever side raises it, where the state is put in breach of its international obligations. And you would say, well, that's not this case, because the state's not in breach of its international obligations by letting somebody in that they shouldn't.
No, it's just gone further
It's just gone further than it was required. Yeah.
Yes, indeed. Thank you. And the final point on 117B, I don't think we spotted this in our survey of the UT decision earlier. Sorry if I'm repeating what was said earlier, though. So core bundle 94, paragraph 16, early on in its introduction to the remaking decision, the UT says, while section 117B of the 2002 Act is not specifically referred to by representatives, there does not appear to be any issue arising out of that provision independently of the consideration of the revocation question, i.e., at least by the time the UT remade the decision, it didn't see that section 117B was relevant at all. And so in my submission, that suggests that it would not have been seen as a material error by the UT had the matter been raised.
Sorry, could you just remind me what paragraph that was? It's
Yeah,
my notes.
page 94, paragraph 16, core bundle.
Thank you.
My next point is regarding the reliance on the neat summary in HARR of KA Nigeria's extensive summary of the impact of the Part 5A regime. And Smythe took us through to several points, but the one I wanted to emphasise was Roman numeral 4. So this is back at page 355, paragraph 18, Roman numeral 4. The purpose was to produce a straightforward set of rules, in particular to narrow rather than widen the residual area of discretionary judgment for the court to take account of public interest or other factors not directly reflected in the wording of the statute. I just emphasise that it was narrow, not extinguish, and therefore matters such as those which I was relying on earlier should still potentially remain in play. The very interesting point is made, quite an important point potentially, about the ambit of Rule 391, and the possibility has been raised that the 10-year proviso is entirely dealing with non-human rights considerations. It's potentially quite an important point. And I understand the point being made, but my riposte to it would be that this simple distinction, proposed distinction between human rights points and other points, only biting on the Home Office's general discretion, may well be untenable. So the suggestion is, we can imagine points that might at first blush be seen as non-family life, non-private life points. For example, compassionate issues, acts of heroism abroad, scientific discoveries that make us want to have this person back, all kinds of things. Of course, those points don't sound in family and private life, but they could, in my submission, be relevant to the proportionality side of the balance, and therefore you can't just say that they are excluded from Article 8 altogether. And that simply revives the question in the first place about what is the meaning of the 10 years proviso. I won't stir that up further. Binaku, I completely forgot about Binaku earlier today, but actually I haven't got anything new to say about Binaku, because I haven't said more generally. My points on Binaku are the same as I made about the Upper Tribunal case of Williams. Essentially, it didn't take account of forward-looking language.
And you can also add that an awful lot of it was conceded by Mr. Malik.
That's true, is true. And finally, the case of KAPP, I'm not sure if the unrepresented litigant in that case really knew what was going on, but in my submission is obviously quite a lot went by assumption in that case, and it can't really be treated as a determinative authority. And those are my points. Thank you very much.
I'm sorry to stand up again. I forgot about the shopping list, and I just want to make sure that the court gets everything it wants. Can I just check? It was confirmation about the immigration rules on suitability, that the non-post-it note. I think the court wanted something from Mr. Symes and me about the position in terms of appeals from error of law decisions and so on. I've spoken to Mr. Symes about one authority, but we could just do a short point on that. Was there another point on the shopping list? I feel that there was, but I can't remember what it was. Perhaps somebody else will remember. It can't have been that important, but if we'll take a look and remember. And then just in the interest of, I hope, saving the court time, I should just say, in relation to the pleading point and Robinson, I just want to be clear what the Secretary of State's position is. I'm not sure if the point is being taken that there was a there was a problem with the Secretary of State's application for permission to appeal from the first tier tribunal to the upper tribunal. If that's the pleading point, it's been dealt with by the upper tribunal's decision and it's water under the bridge. If the point is about the Secretary of State not having a respondent's notice, then the answer to that is the Secretary of State's clear reading of paragraph 14 of the Upper Tribunal's error of law decision was that it decided that the first tier tribunal erred because it didn't apply Part 5A at all. So there's no need, if that helps, for me to rely on Robinson obvious, and that maybe gets rid of one. I don't really think it comes into it. I think that's the issue. In any event, I hope, as we've made clear, that we don't really think any of that is to the point, but I just wanted to, if I could, save the court some time. We'll liaise on the shopping list, and if we think we've missed something, we'll add it. And of course, if the court thinks of anything, please just let us know. Could we get that to the court within, what day is it today? Wednesday?
7 days?
Yes.
Happy to give you 7 days.
Thank you very much indeed.
And as you probably gather from this discussion, we're not going to give judgment today. We'll reserve our judgment.
Thank you.
It'll be circulated with a draft in the usual way. Hardly needs for me to tell experienced counsel. It's just for typing errors and corrections of that nature, or obvious factual errors if we make any. Again, I don't really need to remind you about the embargo and how seriously the court takes it. But we hope to get it to you as fast as we can. No promises.
Thank you very much.
Thank you both very much.
Thank you.
Thank you all very much, and those behind you.
Court is able.